Welcome, 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 everybody. We so appreciate that you're taking some time out of your busy schedules to join us here today. What are we talking about here today? Well, likely estate tax changes and how you can potentially save millions of dollars. It looks like change is coming, and we're here to walk you through that. And we truly believe that this webinar could change your family's future. And just imagine what's possible for your children and grandchildren when you plan, when you think about these issues, and when you put a great plan into place. It's extraordinary what you can achieve when you take the right steps.
I speak for Mark as well when I say we're just thrilled with the response that we have here. It's in a way it is a surprise, but it isn't. We have a few hundred folks signed up for this webinar, and you guys are a step ahead. Just to know that these issues are coming. So good for you. We again special welcome to everybody as we focus in on these issues that are just directly relevant to virtually everybody.
Yeah, and we want to set the stage. These numbers can seem just like abstractions, but just think about how hard you've worked to earn, to save, to invest. Think about all the times you flew coach when you probably could have afforded to upgrade to business class, when you kept your old Mazda, when you probably could have afforded to upgrade to a new Lexus, when you took the mountain view room rather than the oceanfront room on your vacation. All those thousands of decisions during your life to save money so you have more as a nest egg to invest. When tax laws change, if you miss out on the right steps, all of those good decisions can be wiped out. And most people want to protect it for future generations if they can. And truly, if you're not armed with knowledge, these changes in tax law can cost your family millions of dollars. And we're here to take care of you and your family and walk you through it, to give you options. And it's up to you what you do, but we want to arm you with knowledge. And that's our goal here today.
So let's take a second and look at what we're going to cover, what our agenda is. Again, you already have a sense of that, of course. The principal focus is going to be on federal estate gift tax laws, likely changes. We'll go through where things are. We're certainly going to revisit Proposition 19, which of course is California's new law that results in exploding dramatic property tax increases when you, the homeowner, or the other property owner pass away. So we're going to revisit that because it's intertwined. Steps in the context of estate tax planning, if you have real property, are dramatically affected by Prop 19. So we're going to revisit that. Steps to protect your kids and grandkids. We'll look at Dynasty Trust, family protection trusts. As a practical matter, what are the steps that you need to take and that are going to make a great deal of sense for you? And by the way, we have our little reminder at the bottom. This is a webinar. We're not giving specific technical advice to anybody about exactly what to do. It's when we sit down with you that we focus in on your needs. And that's when we obviously are giving you reliable information that's directly relevant to you and your family situation.
And just one note, we're not going to be able to take questions during this talk. We just have too much to cover, too many people here, but you can feel free to submit questions through the Q&A function. We'll try to get to a couple at the end if we have time, but it was a lot to get through here. And for those of you who don't know our firm, welcome. I think most people here, I think this was only marketed to our mailing list. I don't think we did any external marketing. So maybe you do know us, but we're very proud of our history here in the Bay Area. We're lucky to be one of the first firms that really focused on elder law, estate, and tax planning really exclusively, and special needs planning. This is what we do. We don't do a bunch of other stuff and then do this on the side. This is what we live and breathe. Been in Palo Alto for 38 years. When I was like a toddler, I was running around the office here. And we've truly served tens of thousands of people in the community. Again, we're really proud of our connection to the community. We serve people throughout the state of California, though, from San Diego up to Wairika. So really anywhere in California, if you're listening, we're actually going to be talking mostly about federal issues. So these are relevant really all over the country. But for California, we can serve anybody anywhere in the state of California. We're very proud of where we've been featured. The Wall Street Journal, USA Today, local TV, national TV. Our goal is to provide extraordinary value and peace of mind. There is no one size fits all solution. You are not vanilla. It's our job to work with you and whoever we work with to come up with custom solutions that meet your problems.
And yes, that is Mark. That is Mark.
Oh, yeah.
In that picture. Next to his mom and grandpa and grandma. So
yes,
continuing the legacy. As we move on.
And literally, we did write a book on this. We're not we. Mike wrote a book on estate tax planning. It's called Beat Estate Tax Forever. We're not here to tell you to go get this book, just to make the point. We spend a lot of time thinking about this, and this book was actually updated last year in 2020. There's a third edition. We're probably going to do a new edition depending on when laws change here. But the point is, we do a lot of thinking about this, and this book is available to our clients or really to anybody who wants it. But we do a lot of thinking about this and a lot of writing and speaking about these issues. This is, again, what we do. So let's dive into the focus here. The death tax. I think this is kind of a funny image because it's the Grim Reaper receiving a tax bill. I mean, that's great. If when you're gone, the Grim Reaper will pay your taxes, no problem here. But I think we get the point. The focus of our talk is not on income tax. It's on estate and gift tax, also known as the death tax. What is happening? What's going on? When is it going to change? Let's talk about that.
Let's go through it. Okay, so as most of you understand, the current level of estate and gift tax protection is very high, 11.7 million per person. So this means that for a single person passes away, if the estate is at or under 11.7 million, there is no estate tax. Alternatively, we have the opportunity to give away 11.7 million and use up our protection that way. And obviously, that's directly relevant to the topics we're going to visit today. So again, that's per individual. So a married couple, almost 23.5 million this year. The tax rate, 40%. Okay, so what's the key proposal? What we're looking at, this is the proposal that came out of the House Ways and Means Committee, which is relevant because it has sort of there's a number of members of the committee who come from different political and philosophical perspectives. So it's kind of it seems to be where the Democratic Party is at right now. So the idea would be to remove this level of protection and reduce it to about 6 million per person, about 12 million for the couple, keeping the 40% rate. Now, there was a lot of discussion of taking it to 50 or 60%. So far, that has not come up. There was a lot of concern that we would lose this thing called the stepped up basis, which we're not going to go into right now, but again, that hasn't happened. That's not one of the proposals. A lot of discussion about getting rid of some of the discounting strategies that we have used for decades. We think those are so far, those are surviving. Who knows? Who knows what the future is going to hold? But we're looking at a very dramatic change in just a matter of a couple of months. Okay, so estate tax exemption dropping to 6 million or so in the very near future. There are a number of other proposals that are in the wind, that are percolating. Looks like they're going to come to the floor, perhaps in the House first. Some of those proposals, as drafted right now, they would go into effect on the date that the bill is signed. So it could be October 30. And then strategies that you might want to implement before that date are fine. But even though we're not yet at the end of the year, those could evaporate. So again, we just don't know about that. Needless to say, we are watching these developments on a daily basis. Now, importantly, let's say there's no new legislation. Is this discussion that we're having today irrelevant? You don't have to worry. No, absolutely not. Absolutely not. If there's no new legislation, the level of estate tax protection will drop to about 6 million, just a little bit further down the road on January 1 of 2026. The current level of protection sunsets, it ends. So you have to give this attention. We're going to illustrate what happens with inflation and the increasing value of our assets a little bit later. So, never think of your assets as a stagnant number. It's going to be larger than it is today, almost certainly. So again, delays obviously are harmful. It can cost your family millions of dollars. We will have changes coming. Question is, how soon, how many? We will be tracking it. Excuse me, very, very careful. Okay.
Yeah, so it looks like January 1st is going to be a big deadline. But again, we're keeping a close eye. We don't yet know for sure. And I think that leads to the question, do we still have time to act? And if so, what can we do? And the answer is yes, we do still have time to act. And we're going to go through some of the things that we can do. And just to Mike's point just now, many of us don't feel like we have enough to worry about this. I think the fact is, based on the current proposals being put forward and that sunset provision that's coming in 2026. So again, as Mike said, even if nothing happens now, which we think something's going to happen, but it's possible. Maybe Congress just dithers and doesn't pass any new laws. We know 2026 this is going to change. So if you are single and have over a $5 million estate, that's the value of all of your assets, including your home, the equity in your home. Or if you're a couple and you have a net worth of over $10 million, you have to be aware of this, because it is almost certain that you're going to face significant estate tax exposure. But wait, hey, what if you say, well, my estate isn't that large? Do I really have to worry? Well, the estate tax exemption, at least up till now, has been indexed with inflation. So it goes up a little bit each year, but we're talking like 1 to 3% a year. The value of your estate is almost certain, we can never make guarantees, but it's almost certain to grow much faster. If you own stocks, real estate, other investments, and you achieve 7.2% growth per year, the value of your estate's going to double every 10 years. Now you have expenses and it's not quite that simple, but the value of your investments, if you don't touch them and they grow at 7.2%, will double in 10 years. And hey, this year, we updated this morning, so we know the market's down recently, but the S&P is up 33% this year to date. So if you had money invested in the stock market, the value of your estate went up by almost a third, at least that part of it. So the value of our estates are going to go up. The exemption's not going up, and it's probably about to go way down. So we just want to make the point that you don't want to just think of your current numbers, the current value of your estate. You need to think about what it's going to be. Just to illustrate this point, many of you out there, this is probably very familiar, but just the rule of 72. If you grow at 7.2% per year, numbers double every 10 years. And if you achieve 12% returns, which many people have over the last few years, the value of your investments or your estate can grow every 6 years. And then it doubles again every 6 years. So it's compound growth. So bottom line is, your estate is probably bigger than you think, and it's probably going to grow faster than you think. That's just a fact. And as inflation comes into our economy, the value of our assets is probably going to grow even faster. So we just want you to frame your thinking around this. This is not a static problem. You got to look to the future. So let's talk about some strategies.
So we don't want to oversimplify, but let's just to get some principles out of the way. Susan, an estate just happens to be $11.7 million, which I remind you is the current level of estate gift tax protection. She gives it all away before the end of the year. Done. She avoided all of the estate tax. She paid no gift tax. She does have to file the gift tax return form 709, but you're reporting to the IRS. You're saying, hey, I made a gift. I'm using my lifetime $11.7 million protection, no tax. Now, very complicated. There's other issues. There's Prop 19. There's stepped up basis. There's how you feel. I mean, we're not oversimplifying. We're just making the point. Okay. What if she does nothing and passes away after the law changes and the level of protection drops to 6 million? The change is dramatic. Over approximately $2.28 million goes to the government in the form of estate taxes. And the way I think about this, by the way, is, it's more than money. It's more than money. It's disruption. It's being forced to sell assets that were so important to you and your family, having to sell the vacation home, whatever it may be. So, these aren't just numbers. I mean, these go to the core of our family values, and why we're working and why we're trying to build our estates for the benefit of our families and of our communities. So again, it's a complicated thing, this whole idea of gifting.
And just to be clear, I realize the top date should be 12/31/2021, not 2022. I'm going to fix that going forward. Just want to make sure nobody's confused there.
Okay, so let's take a slightly different perspective on this. And let's say, there's Susan, she has 11.7, and she decides to give away 6 million before the end of the year. And then she passes away subsequently. Well, at that point, everything in her estate will be exposed to the estate tax. She used up her 6 million, but that's it. There was nothing left. So $2.28 million will go to the government, and that's assuming no growth in the value of her estate. So in other words, if you make a small yet substantial gift, it may not do you any good. It may be very, very modest in its impact. So again, the whole idea here is analyze your situation, see where your comfort zone is, and understand what you're getting and maybe what you're not getting when you consider some of the strategies that are available to you.
That's right. So, how many people here have seen Shawshank Redemption? If you haven't, this probably won't mean much, but I think most people probably have. I think it's like the highest rated movie of all time on IMDb. It's one of my favorite movies. Why am I bringing up Shawshank Redemption? Because there's a scene in it where Andy, and this is not a spoiler for the big movie. If you haven't seen it, you should see it. It's an amazing movie. This is not a big spoiler, but Andy Dufresne, the prisoner, he's the lead character in this movie. There's a scene where he's doing some work outside of the prison, and the evil prison warden guy, cop, is talking about tax problems. And Andy Dufresne overhears this, and he's an accountant. He knows taxes. And he's not the best communicator, but he overhears it. And he says, wait, I think I can help this guy. Maybe that'll help me. And he approaches the warden, and his first line, which almost gets him killed, is, do you trust your wife? Why would he ask the warden, the psychotic warden or psychotic cop overseeing the prison, do you trust your wife? Well, because Andy Dufresne had a tax tip that only worked if the warden was willing to give some money to his wife or do something involving his wife. I don't remember exactly what it was, but that's relevant here because do you trust your wife or your husband? It doesn't matter if it's the wife or a husband or spouse. That's what a SLAT is. So what is a SLAT? It's a spousal lifetime access trust. This is one of the tools that we want to illustrate. And just to be clear, we're not here to go through every estate tax planning tool that there is. We're here just to give you some examples of a couple that we have used recently that we think are good just to understand the basics of. Don't worry if you don't understand everything or all the details, but let's talk about what a SLAT is. So one spouse here sets up an irrevocable spouse trust for the other spouse using his or her $11.7 million exemption right away. So you say, before the end of this year, I'm going to put $11.7 million, my entire gift and estate tax exemption, into a trust for my spouse. Now, why would I do this now? Well, it's a way of future-proofing your plan by protecting at least $11.7 million and future growth. Because again, we talked about the growth of investments. That 11.7 can keep growing over time from a future estate and generation skipping taxes, even if exemptions are reduced in the future. So if you put money into one of these trusts before the exemption goes down to 6 million, you put 11.7 million in, you should be protected. That money is out of your estate. One spouse has used the exemption and they've sort of locked in that 11.7 million in protection, and it can be set up for a spouse and can continue for future generations. And this is a way, when you do the math on 11.7, assuming the exemption drops to 6 million next year, well, it's a way to avoid a minimum, and I mean minimum, of $2.4 million in future estate taxes, assuming the exemption goes to 6 million a person. And again, I say minimum because once that money's in that trust, it is already out of your estate, and that trust is set to serve your family for a long time. There should be no future estate taxes for multiple generations if it's set up right. So that future growth is also protected. So imagine you put 11.7 million in it now. Okay, you save 2.4 million, but in 10 years and 20 years, that might be 20, that might be $30 million. So the number, the tax bill that you can save by doing this now before this deadline passes is extraordinary. It could be huge. So, but you do have to trust your spouse because this is an irrevocable trust. You know, for this to work, you got to tell the IRS, I gave up my rights to this. This is for my spouse. It's no longer mine. So there are some risks there, but this is a relatively elegant way to protect a substantial part of your estate. And let's go through an illustration to this. And again, we're not going to go through illustrations of every estate tax planning tool. I just want to show you a little bit more about how this might work so you understand how we think about this. So let's talk about Fred and Wilma versus Homer and Marge. Iconic characters, and I think we can all agree that Homer's not really on top of things. Fred and Wilma, let's say they're on top of things, and their shows have been very popular. They've made a ton of money, so they both Fred and Wilma and Homer and Marge have $16.7 million estates this year. Fred and Wilma take steps before the end of this year to plan for estate tax changes. They set up a SLAT, a spousal lifetime access trust. Homer and Marge obviously don't plan because it's Homer. Come on. Both couples live another 10 years, and their estates grow to $30 million each. So they're quite wealthy. The value of their investments grow. They get the royalties from their shows. What happens? What's the difference when Homer and Marge pass away versus when Fred and Wilma pass away? Well, no action. Homer and Marge don't plan for estate taxes, but they invest well. As I said, their assets grow to $30 million. The exemption goes down to $6 million. So what does that mean? $30 million estate, both Homer and Marge can protect $6 million of that. So $12 million is protected, but that leaves $18 million exposed to a 40% tax. That means $7.2 million go to the IRS when they pass away. Their children end up with $22.8 million. Now, I'm not crying for their children, but still $7.2 million was lost in estate taxes. Let's compare. Don't need to worry if you can follow all of these points. I just want to make the point of how much money can be saved when you set this up. So Fred sets up the slat for Wilma using his entire $11.7 million exemption. So there's still $5 million not in this trust, this irrevocable trust. So assets in the trust grow to about $20 million when they pass away. So that slat didn't just protect 11.7. Remember, the growth of assets in that trust are also protected. Assets outside of the slat grow to 10 million. Again, the exemption goes down to $6 million a person. When they both pass away, the $20 million in that slat goes for the benefit of their children. There is no estate tax. The $10 million outside of the slat, well, that's not protected. There's going to be $4 million in estate tax because, again, there's going to be some estate tax exposure. The net to the children is over 28.4 million. Bottom line here, Fred and Wilma saved almost over $5.5 million. They saved $5.6 million for the next generation by setting this up. It locks in the current high exemption and it removes the growth from their taxable estate. So again, you don't need to follow all of these numbers. Your head might be spinning a little bit. The point here is not to go through the math in too much detail other than to say the impact can be absolutely massive and really, really powerful. So taking these steps now, we're not exaggerating. They can save millions of dollars in the future.
So now we'll briefly visit a few of the other strategies. Again, we spent a lot of time thinking about which examples do we give, which do we emphasize. The whole idea is to try to make this fundamentally palatable for you so that you get the flavor of what is done. Nothing simple, no one size fits all, but here are some other ideas. One involves using an LLC, sometimes a partnership, frankly. It's a way of getting assets out of your estate, keeping a degree of control, and having an income stream. For example, assets might go into an LLC, a limited liability company. You, the parent, may keep a degree of control. You may get a salary for managing the LLC. One of the reasons this is considered is we can integrate it with the family protection or dynasty trust planning that keeps assets out of the estate of the next generation and then the grandkids, saving enormous amounts for the great-grandkids. And it also typically allows us to take advantage of what is called discounting. Again, my book walks through examples of how this is done. But the idea here is that if these entities are properly structured, we can discount the value of the gift. If there's issue with control, with marketability of assets, a number of factors with which so many of you are familiar. So the discounting, for example, would allow somebody to perhaps give away 14 million and discount the actual value of the gift down to 11.7, eliminating complete exposure to the estate tax. So again, saving millions. I guess we keep saving millions. I mean, it sounds like we're exaggerating and we're almost a little uncomfortable with it. I am. We hate to exaggerate. We're not. We've taken a real hard look at the numbers, and I think you can see it's practical reality. Just how do you get there? That's the challenge. So let's look at another real quick list of some of the other strategies and tools that are available. There are ways of structuring the trust so that there's opportunities to undo a portion of the planning with something called a disclaimer. Formula gift to charity. This means something very simple. You could say, I leave to my kids the maximum number of dollars that can go without estate tax. Everything else goes to my favorite charity. You just eliminated the estate tax. Maybe perfectly comfortable for many of you. There's the personal residence trust where you convey title of your residence to the kids, capturing significant discounts. Grantor retained annuity trust. Many have heard about GRATs. They're in the news relatively often. Irrevocable life insurance trust. If your life insurance policy is in one of these trusts, the death benefit is not part of your taxable estate. We can shift policies into it to avoid that outcome. Crummy trusts. Love those grandkids. Regardless of the size of your estate, this should be considered. Here's the idea. You're aware of the $15,000 annual exclusion. You can give that away to anybody you wish. You can put that money into a trust for the benefit of your grandkids. As a couple, you can put in $30,000 a year. So that's going to grow. Generally speaking, it's preferable to take this approach rather than 529 plans. The money isn't restricted with the crummy trust. It can be used for education. It can be used for other purposes. It can stay in the trust until your grandkid is 30, 35, 40. You pick the age. Again, this is illustrated in my book, but it's a very practical way of removing significant assets from your estate, getting it to the next generations in a way that gives you a very high level of satisfaction.
And I'm surprised that you didn't use this as an excuse for us to put a photo of Miles, your first grandchild. My sister Jamie had an awesome little dude a year ago. He's about to celebrate his first birthday. So happy almost birthday to Miles, your first grandchild. So this is all very top of mind for you right now.
It sure is. And that leads directly to another approach that a number of our clients have chosen to implement just over the past month, creating a family foundation. It doesn't have to be $100 million to create a foundation. A couple of billion, which is not insignificant, can be enough. So the idea there is you create the tax-exempt organization. You leave assets to the foundation to remove it from your taxable estate. You define the purposes of the family foundation. It perpetuates your values, the family legacy. You can be as creative as you like in identifying what the purposes are. And some people are very creative as they identify the objectives of the family foundation. Family members can work in the foundation. They can take a salary from the foundation. So again, it's one of the many tools, and this can give you a lot of satisfaction as you just think about the legacy that you're leaving for your family for multiple generations down the road.
Now, we just want to flag, we mentioned this before, but we think it's important that you understand this as well, that there's a timing issue. And we mentioned that it looks like the exempt, even if a law passes in the next month or two, which we think it will, but we don't know for sure. But even if the law passes, we think that the exemption would not go down until the beginning of next year. We'd still have the end of this year to plan and to use the higher estate tax exemption. That being said, there is some discussion that the day the law is signed, some strategies that we've used in past years will no longer be allowed. Now, we don't know for sure if this will be the case, but this just means that if we see this law coming, we do, it makes sense to act sooner rather than later, because waiting will only mean lost opportunities. And you can see what's happening. You may want to get things set up and ready to go right before the deadline. And hey, if the deadline is extended a little bit, you're okay. But if it happens, you're in trouble. So the point is, the day the law is signed, some of the strategies we talked about on previous slides may no longer be possible. Now, we don't think that's going to happen with the exemption. We think the exemption, the 11.7 drop to 6 million, we don't think that's going to happen until January 1st, if assuming this law goes forward. So just be aware of it. Waiting is very risky. Don't miss these opportunities while we still have them. Now, critical issue for anybody here who owns a home in California, and especially if you own rental property as well. So Prop 19, that's not the focus of this talk, but this just speaks to the importance of understanding all of the issues as they come together. You don't want to just think about estate tax by itself. We got to think about capital gains taxes. We have to think about property taxes, on top of course, family dynamics, your values and family issues. But Prop 19 is a huge deal. It complicates planning for real estate. Now, why is that? Before Prop 19 became law in February of this year, parent-child transfers of real property were largely protected from reassessments of property taxes. So the primary residence that mom and dad owned, plus up to $1 million in assessed value in rental properties or second properties, could all go to children as long as it was parent-child without a change in property taxes. And that's a huge deal. If you own a house in the Bay Area, or really anywhere in California, for over 10 years, for 20 years, for 30 years, your assessed value, your property tax value, is probably a fraction of the fair market value, what the house is actually worth. So that means you're getting a big benefit. You might be paying, we have clients who are paying, $3,000 a year in property taxes on houses worth $3.5, $4 million. That means if they're reassessed, property taxes can go up to like $48,000 a year. The point, Prop 19 gutted these protections. What happened? Well, your primary residence, and this is where we saw a lot of people were confused. I think a lot of people saw marketing about Prop 19. They thought, okay, well, it's not going to really affect me because Prop 19 says my primary residence is protected. If it goes to my kids, no reassessment of property taxes. And that's just wrong. Now, going forward, if a primary residence goes from parent to child, only the first $1 million in fair market value is protected from a reassessment. So if your house, the fair market value is more than $1 million over the assessed Prop 13 value, that means any fair market value beyond that is going to get reassessed. So again, let's go back to the example. You're paying $3,000 a year. The house is worth $3 million. You pass away, the first $1 million in assessed value beyond that $300,000 assessment, that's protected. There could still be a $28,000 a year reassessment. And that your kids only get this protection if they live in the home too. So if one of your kids doesn't live in the primary residence, you don't even get that $1 million in protection. Notably, rental property, vacation home, any other property outside of the primary residence, zero protections. They are going to be fully reassessed unless you take steps to plan. So this is not, again, to illustrate all the details of Prop 19, just to point out that Prop 19 is a major issue. And we think about these gifting strategies, these trusts, we got to think about how Prop 19 will affect the transfers. And just to be clear, we do have tools available to prevent massive reassessments, and we can coordinate these with estate tax planning. So it gets fairly sophisticated and complex, but there are ways to deal both with the Prop 19 issue and estate taxes at the same time. But we just have to be cognizant of it. You don't want to just make a big gift thinking, oh, that was a great move for estate tax purposes, but oh gosh, now we're facing a $40,000 a year increase in property taxes. We didn't think about that. So just want to flag it. And this is something that we always bring into account when we're working with clients and we talk about these strategies.
And by the way, you may have an estate that's under 6 million, but you may have a piece of property that's worth 3 or 4 million, which means you don't have the estate tax concern, but you definitely have the Prop 19 concern, which can make the difference in terms of whether or not your kids can keep that property.
Yep.
So now we'll take a moment and think about how you might structure assets for the next generation and the next generations. This is Wall Street Journal from quite a few years ago, but the quote remains perfectly valid. Dynasty trust, family protection trust, big tax savings, and help protect family money from creditors and ex-spouses, from that divorcing daughter's ex. Okay, so let's walk through why we are so high on these. If you're our client, and many of you watching we've talked about this, about 70% of our clients have created these trusts for their kids. So let's go through why they make such an enormous amount of sense. They border on being a no-brainer. Okay, so when you pass away and you leave assets for your kids, and as you structure any tax planning that you do, you can either have those assets go directly to your kid, or you can have them go into a trust for the benefit of your kid. So if you don't have a special needs situation, which of course is different, this is the approach that we recommend. And why? Because of the protections. Number one, what if your child inherits money from you in her own name and subsequently endures a divorce? She may have retitled a lot of those assets with her spouse. Half of the assets that got retitled could be lost in the divorce to the other spouse. It would make you roll over in your grave. So if you instead leave assets in one of these trusts, the assets are segregated in the trust upon your passing. If your daughter endures a divorce, all the money you left her is going to remain with her. So divorce protection is the moving force for most moms. I've learned over the years, moms care about that primarily. Second is litigation protection. If your child inherits money and it's in his name and he's sued, that money can be reached. If we have it in this trust, we've erected a very high barrier, very high level of protection from somebody who might sue your son. Again, litigation protection can make all the difference in the world. But that's not the biggest benefit. All or most of the assets you leave your child in this trust are there for your child to manage, to invest, to enjoy, but that money is not part of that child's taxable estate. So let's take a simple example. They inherit $6 million, $3 million in that trust. They're smart. They're lucky. By the time they pass away, it's grown to 15 million. Now, if that 15 million was in their estate, enormous estate tax exposure. If it's in this trust, it is not included in your child's taxable estate. It passes intact to the next generation, which, by the way, for the grandkids, same protections. These trusts live on. If you like, you can allow your child to be the trustee of his or her own trust. That's up to you. Again, the idea here is to build in protections for at least 2, if not 3 generations, integrated into your plan. Even if you don't have estate tax concerns, even if your estate is well under the level of protection, this is something that you should integrate into your plan.
Yeah, I think that's a key point. Even if the estate tax numbers are not a concern, this is something that should absolutely be integrated into your core estate plan. I just consider this to be a foundational part of anybody's plan. We can help you with that. And just to that point, there is no one size fits all solution here. We're not here to say you need to do X, Y, or Z. We have to weigh, as I said before, capital gains tax, property taxes, and of course, your personal goals and concerns. And we have to be thoughtful about protecting assets for future generations to whatever extent you want to do it. And just to be clear, we get it. Not everything is about tax. We're talking about tax, but life is not all about money. Life is not all about tax, but knowledge is power. And we know you worked so hard for your assets. And it's hard to make. The world is expensive. It's tough, especially in the Bay Area. Just affording a house is crazy. So a lot of people want to at least give their kids the option of staying in the area or preserving the family home or that rental that you work so hard to earn or that business that you built and all you work so hard for. So it's our job and our goal to bring this all together for you as part of an integrated plan. That's, I think, the key point. Again, we went through a lot of different concepts here. The point is not for you to understand all of these. There's different tools for different families, different situations. And maybe you say, hey, you know what? I don't care about these taxes. That's fine too. We're here just to make sure that you're educated and empowered. And by the way, if you have friends who could benefit from this, tell them about this. We're probably going to make recording this public. We're also giving several more webinars, by the way. We're going to give, I think, 4 more, which is a little overwhelming because we had a bigger response than we expected to this, but we're going to be giving more webinars Thursday and a couple next week. So feel free to tell your friends, invite them. They're all free. And don't lose this opportunity. If any of this brought up a concern or made you think, oh gosh, I need to understand this more from my situation, meet with us. Get informed. We can go through your situation. We can go step by step to say, okay, you tell us what your worries are, and we can say, here are the options. Here are the steps you might take. Here are the things you have to worry about. It's our job to help propose to you different ways to preserve your assets. We don't have a crystal ball. We don't know what's going to happen with the law, but there's no benefit to waiting. Get the process started. And if the law doesn't change, okay, you're no worse off. But if it's changing, there will be a surge of interest, and you guys are ahead of the curve a little bit. By being here, you're ahead of the curve. You have a little bit of time. So set that meeting right away. And I just want to introduce our team of attorneys. We have a fantastic team. Nick Klingenberg, Renee Conrad, myself. Francis LaPole is the head of our tax practice. He will be overseeing all of our tax work. We have Michael Gilfix at the bottom. But Nick and Renee, they're not part of this presentation, but they're both amazing. Nick is licensed to practice in New York. I think that's notable because New York has a state estate tax. So he's been dealing with different estate tax issues for many years, even before he joined us several years ago. He is awesome. Renee, over 20 years of experience. She's fantastic. We all work together as a team. Anything you'd add here, Mike?
No, we're available. We've really cleared the calendars, especially for the folks on the top row. We've cleared the calendars to make sure that we can accommodate folks who want to come in, which of course is what you should be doing. There's a few bucks in attorney fees. It can be I know it's easy for me to say, but it's true. It's one of the best investments you would ever make. So, we certainly encourage you to do that. We do, I'll emphasize, as Mark said, we work as a team. We go over issues, planning, suggestions, and proposals together to make sure that we identify all the issues that come up with the best coordinated solutions.
Yeah, and so again, take this, do what you want with this knowledge. But if you want to take action, we're here. And again, I know it, we're beating a dead horse here almost, but there is a deadline coming. And in our experience, when there are deadlines, we get a trickle of interest, and then right before it spikes up, and we sometimes can't even accommodate everybody. So set a planning meeting with us. So you can at least understand the issues you face and the options that you have. I'd say set it sooner rather than later. Our availability will be limited just because this is time limited, and we have the holidays coming up and all that. It gets hard towards the end of the year. Set a planning meeting with us. We do bill hourly for our planning meetings. We will dive into your issues, and we can very efficiently get to potential solutions, recommendations, and can get the process started. So we're ready to go as soon as we see what happens with Congress, which we think it's coming. But you need to be ready to go right before this deadline is here. If you call us on December 29th in a panic, we might not be able to do much for you. So let's get the process started right away. You can call our office at 650-493-8070. You can email Tim Sung on our team. He's fantastic. Email him at tim@gilfix.com. He can help you to coordinate a meeting with one of our attorneys. You can also leave your name and contact information in the chat function if you want us to just reach out to you. We're going to copy and paste all the names and emails we get. If you send us a chat directly, you don't have to do it to the whole group, but send us a chat directly and we can gather your information. That way we'll reach out to you to set a meeting. But I just want to emphasize, this is all about getting informed. You are ahead of the curve. You now at least are aware of what these changes are likely to be, and you're aware that there are steps you can take to protect your family. So we're here for you. Tell your friends and family about these important issues, because this is going to affect a lot of families in California, especially if you own a home. So
please do that. We really targeted 45 minutes for this webinar. We're getting close to that. A couple of questions, a lot of questions, frankly, came in. I'm just going to pick some that I think will be generally applicable. One, it's actually about the AB trust. And so many couples have the AB trust. And the point that the individual made is that, well, I hear I don't need an AB trust anymore. Should we change it? Very likely, I'll just say that if you have an AB trust where the estate, the trust divides into two after the first death, that may be unnecessary at this point because it's something called portability. We can still capture tax protection. So very individual as to whether it makes sense to retain that or not. Another question is, how does the SLAT, the Spousal Lifetime Access Trust, compare with the revocable trust? Your revocable trust, which is a great trust, you need to do it to avoid probate, for management benefits. If you're a single person that does no tax planning at all, assets in your revocable trust are in your taxable estate. So the idea is get it out of your taxable estate with a SLAT. It's there for your spouse, not in either person's estate. So, dramatically different. Again, a revocable trust does not do any sophisticated estate tax planning whatsoever. And I've got just
a reasonable question is about our hourly rates. I think that's good for you to know. So the hourly rates for our attorneys range from $495 to what is yours?
$695.
$695. So a range $495 to $695, and that's the billing rate when we meet with you. You're not obligated to do anything else, and our goal is always to give you an idea from that first meeting what the cost would be to carry out the recommended plan.
Sure. And I'll just do one more question. The comment is, can I shift $11.7 million to the family protection or Dynasty trust that we prepared for your two kids? You'd still be keeping some money, it says. You trust your kids. Yeah, you could. That is a way of removing the assets from your estate. It would save millions. Really careful, though, remember about Prop 19. If real property if there's a change in title and you're not careful about it, that could generate a reassessment at the time. Loss of stepped up basis. Again, often it makes sense. You got to walk through a number of elements of the equation as we figure out what is best for you. And a bunch of questions about SLATs and a few others about GRATs, beyond our ability to delve into these issues today. So, I think we thank you. We covered a lot.
We did.
Probably not, certainly not everything. We do look forward to seeing you. We're practical. We're working very hard to be on top of these issues and to develop solutions for you. So we look forward to seeing you. All of our attorneys do be in touch. Mark, any final thoughts?
Yeah, so we have some more webinars happening. Go to our website, gilfix.com, go to the events section, and we have a listing of all the follow-up webinars. Feel free to attend again if you'd like, or let your friends know. These are big issues, and we always know a huge chunk of the population this affects isn't even aware of what's happening. So we want to at least let you know what's happening, then so you make an educated decision as to whether you take action or not. We're here to help. So thank you for those of you who put your information in. We will reach out. And again, you can reach out to Tim directly and call our office. But thank you guys so much for spending time. I'm sorry we can't get to all the questions, but we greatly appreciate your time, and we hope you got great value out of this. Again, I hope everybody's staying safe, sane, and healthy in these challenging times. And here we are, a little bit bigger. And it was great to connect with everybody. So take care, and we'll hopefully talk to you soon. Take care.